Thanks, and welcome to the follow-up on the legal hot topics. Um, this is, as is implied by the name, it's a follow-up to the discussion that we had on Tuesday, which was a jam-packed full of legal updates from some of the brightest minds in our industry, and brightest legal minds in our industry. Um, Now, before we get into this again, I'd like to briefly say who's here. So, oh, and sorry, I want to thank our sponsor as well, which is CDAS, which is the firm where Nancy Wolf is a partner. She's also the general counsel for DMLA. She is one of the speakers. Next, we have Margaret Vincent. Who is a VP of Content and Legal at Stocksy United. Then we have Sejal Richberg, who is the Assistant General Counsel of Intellectual Property and Litigation at Shutterstock. And finally, we have Dan Pollock, who is an attorney at Dipchand LLP out of Toronto. And I forgot to introduce myself. My name is Paul Reinitz. I'm the Director of Legal Advocacy and Legal Operations at Getty Images. Now, before we get into the topics, I want to again give our legal disclaimer that the information presented today is for general guidance and not to address any specific matters. The application and impact of laws can vary widely based on the specific facts involved and where acts happen. As such, the information shared today should not be used as a substitute for consultation with your legal counsel. Seek legal counsel if you have specific questions. And also, the opinions expressed here today are those of the speakers and may not reflect the opinions of their employers or of the DMLA. So, as I said, there was jam-packed information on the session on Tuesday. And we actually did not get through the entire presentation that Nancy Wolf was giving on case updates in the US. So we're going to start with that. And then we're going to open it up for any questions that anyone has on any of the topics that were presented on Tuesday. And I'll throw up a reminder of the agenda so that it can spark your memory if you have questions. So without further ado, let's open it up for Nancy.
We're going to talk about the thorny issue of tattoos. As you know, there's barely a celebrity sports star or probably anyone under the age of, I don't know, 30 who doesn't have some tattoos. And it becomes increasingly difficult to determine whether there would be any copyright issues in displaying, distributing images that have tattoos. And the other sort of corollary area is graffiti and murals, because almost every city now also has buildings with murals. And because tattoos as well as graffiti qualify as works of visual art under the Copyright Act, the fact that they're on someone's skin doesn't mean that it's any different than being on a work of art on a canvas. So next slide. So those leading, the decisions leading the day are all the ones involving video games, because there's a lot of money in video games, and the reproduction of celebrities and stars in video games is so authentic. I mean, they're avatars, but you can barely sometimes now tell the difference between an avatar and film of a real player. So Take-Two Games has a game called NBA 2K, and it allowed players to control famous basketball players like LeBron James, I'm not even going to pronounce these right, Eric Bledsoe, and a tattoo licensing company sued for the use of tattoos on the players. And in this case, the district court held that the use of the tattoos did not constitute copyright infringement. And there were a lot of discussions that were really interesting in this case, particularly in the area of implied licensing, because when you have a tattoo put on your arm by a tattoo artist and you're famous, sort of there must be some understanding that that celebrity is going to be depicted, particularly a basketball player whose arms are typically show, with these tattoos. And so there was a lot of talk about the license the tattoo artist granted to the player in creating the tattoo. Also in this case, the tattoo on the player, some of them were based on his baby pictures, and they weren't a lot of the designs were really directed by the basketball player. So the court came up with a lot of areas of copyright law that were really interesting. They talked about how they weren't substantially similar between the game and the actual player. They were within this license, and they also talked how it was transformative, that it was for a very different use. And in this game, the players were fairly small and fleeting. They were actually, playing basketball. So it wasn't like you were just focusing in on each tattoo. It was they were moving. So you would have to really sort of freeze a frame in the video and look at them. And the court found they were conducive to fair use. There was no more use than was necessary. And they also looked at the revenue. The tattoo owner of the copyrights had never made any revenue licensing tattoos for this purpose. They only made revenue by actually inking somebody. So we thought this case was great. It's so favorable. There's now some language in the case law about an implied license, that when you put a tattoo on someone that is well known and you expect will be filmed and in the news, etc., that would not be an infringement to show the person's actual likeness in an authentic way. Then a case came along in Illinois. The case I just talked about was in New York. That had sort of the opposite result. So now we are also in this limbo land of like, can you depict people with tattoos or not? And of course, it's another interactive game company, and this dealt with Take-Two Interactive. So the tattoo artist sued Take-Two for depicting not a basketball player, but a pro wrestler, Randy Orton, in their game WWE 2K without licensing his tattoos. So you can see there that the arms are heavily inked. And of course, with any kind of case, a defendant always wants to bring a motion for summary judgment to get a case dismissed without ever having to go to a jury and have a jury decide the issue. And so in making this motion to have the case dismissed, probably thinking the world looked pretty good after the Solid Oak decision, the court held there was actually a genuine issue of material fact about whether the plaintiff intended to give Orton a license to use her designs. And so that case, the actual intent, which is something that is a factual issue, wasn't clear and wasn't obvious, and ended up being a question for the jury. So the court said the case could not be resolved on summary judgment. That typically means a case will be settled. So those are two very recent cases about tattooing. So this is why everyone probably gets frustrated when someone asks a lawyer a question, because the answer now about tattoos is, well, it will depend on the intent of the tattoo artist. So, it would be great if every sports player actually got a license from a tattoo artist when they were getting ink, but, that's, those kind of practices probably don't happen frequently enough. We're going to talk about another subject, which is very hot these days, embedding and social media. A lot of cases involving Instagram, because Instagram has an app that allows embedding of Instagram posts, and it has a policy that sort of encourages the media to create digital stories using this app. And the app will also provide attribution to the Instagram user. And any Instagram user that has a public facing Instagram account this app will apply to. If it's private, it won't. So there have been some recent cases involving whether this embedding policy violates copyright, or if the terms of service that an Instagram user uses when choosing the public feature that grants Instagram a license and the right to grant sub-licenses, is that use of the Instagram API, embedding API, actually a sub-license. And so there's been a couple cases in New York where the court's been asked to look at it and initially said, yes, it was, could be a sub-license by looking at the language. And then on reconsideration, the Sinclair case said, no, it may not be. So in Sinclair, this was the photographer Stephanie Sinclair sued Mashable and the parent company because they embedded her image in an article using this API. And so, as I mentioned, the court initially said it wasn't copyright infringement because Sinclair agreed to follow Instagram's terms of use and was in the public, had used this public feature. And then later, the court, you can make a motion to reconsider if you think the court perhaps failed to look at some evidence that was available. And she said it was really unclear whether Instagram exercised its right to grant a sublicense to Mashable. So summary judgment was inappropriate, and that case is moving forward. So we don't have a clear answer on that either. And Mcguckin versus Newsweek, where in fact our firm did represent Newsweek, so full disclosure. Very similar facts. It came after the Sinclair case, and the court referenced the Sinclair decision and to say that the Instagram terms of use gave Instagram a license to sublicense Mcguckin photos, but the court again did not see evidence before the court of an actual sublicense between Instagram and the defendant. So this issue of whether Instagram's API is an actual sublicense is an open question. Instagram has come out, or someone from Instagram made a public statement recently saying that it was not a sublicense, but of course all these actions took place well before that statement. I think it's very confusing to publishers who, have picture departments that are not, lawyers, who would think that because an app is offered, they're allowed to use it without understanding. And probably be better if Instagram gave a little more information so publishers really understood what they should and should not do. The other issue is, when do you have standing to sue under copyright? The case I'm going to talk about is one from the stock photo industry, where we've been making a lot of interesting law about copyright. And so we'll go to the next slide. This deals with Stock Food America versus Adagio Tea Company. So Stock Food is a stock photo company, and they have been doing content enforcement for copyright for their contributors, and they sued Adagio Tea for making use of photographs without properly licensing them. So Adagio examined the standard agency agreement between Stock Food and the photographer and argued that Stock Food did not have a sufficient copyright ownership interest under Section 106 of the Copyright Act. This issue had come up before, particularly with a company in, I think it might have been Nevada, who was doing a lot of copyright enforcement of articles. And they had the right to sue, but they didn't have any rights under Section 106 of the Copyright Act, and the court found that that did not give any rights for them to actually bring a copyright claim. So let's go to the next slide. So in this instance, the court found that Stock Food did have a copyright interest in the copyright material. So the argument is that if you only have a bare right to sue, it's insufficient. But under 106, you have 6 exclusive rights. that a copyright owner is granted the right to reproduce, the right to distribute, the right to display, and that would also be the right to create derivative works and to broadcast. So the agency agreement was held to be compliant because it granted stock food exclusive rights to offer license to reproduce, distribute, and display the content. And though it didn't have every single word that would be in the Copyright Act, the court found that it was enough to comply with the Section 106 ownership rights in stock food. So here you have a difference. I think if you have an representation agreement where you only have non-exclusive rights, that you probably would not have sufficient rights under Section 106. But if you have exclusive rights to represent content, I think you would satisfy the requirement that you had enough of a copyright interest to bring a copyright claim on behalf of your contributor. Of course, there has to be a registration in these images as well, from the slides we went through earlier last Tuesday about how the Supreme Court has now required you actually to have a registration in hand before you can bring a claim to sue and not just have an application.
I think that's the last one.
I think
Nancy.
that's it. Okay, so that wraps up sort of the most interesting cases since last year. The one case I did talk about last year, which I don't have a slide on, had to do with the case involving the Warhol estate and the Lynn Goldsmith photo, where the court found that was fair use. That is up on appeal, and there was just oral argument. And the issue is, if something's a Warhol and known so much as a Warhol, does that have a sort of any impact on the fair use analysis? So I might have a new update on that one next year.
Thank you, Nancy. So we're going to open it up now to questions that anyone may have. We'd like to hear from you. If you can press the participants button, raise your hand under there, and we'll unmute your mic. And you can unmute your video too if you'd like to everyone to see you, and we can have a discussion. So I see that we have one hand raised already. Tom, if you want to ask your question.
Yeah, I'm wondering on the journalist rights area, you talked about public versus private property. And I'm just wondering, how do you make that differentiation? And are there kind of gray areas? Like I know we hear sometimes that, a public space that you can enter easily, even if it's private property, might still be considered public from a privacy standpoint. Like you might be able to photograph in a shopping center, for example. I'm wondering if that's the same kind of public-private distinctions apply when it comes to whether someone can kick you off that property. Say there's a rally taking place at a shopping center that's technically private. Can you shoot there and capture it? Can people ask you or tell you to leave? And then I'm also wondering, like sort of as a building onto that, if you're capturing something that's extremely important to capture, are there ever situations where journalists are allowed to be on private property and to stay where otherwise it would be trespass? And I'm thinking particularly about investigative journalism and that kind of thing. Have there been any cases that talk about that at all, either in the context of protests or something that's so longer term, like capturing documentary footage to expose labor violations or health and safety violations?
Yeah, so in terms of public versus private, again, like the most clear options will be like outdoors is generally public, and then indoors gets a little bit dicier. I'd imagine, I can't speak at this moment to particular sort of changes that might shift something from private to public or vice versa. I'd be happy to take a look at that a little bit more deeply and get back to you. In terms of the rights, I think in like ongoing when topics important, there are very different rights and limitations if you are a professional journalist with an organization that has some clout and some history versus if you're a blogger or doing more citizen journalism. It would depend in some cases on what rights you had as a journalists. I can imagine instances where that could be addressed differently. Again, I don't have particular examples. But
My thought was, if something is like a shopping center, you're still an invited guest. And if you were doing something that might be interfering with the public's access, you know, or blocking things with cameras and all, you probably could be asked to leave. I know, for example, in New York City streets, you might need a permit if you were going to set up like tripods and you had assistants and video cameras, but you're just carrying a camera, you wouldn't need it, and you can take things on the street.
Tripods definitely seem to trigger.
Tripods always.
Yeah. I don't know if it's because you look more official or what, but every time I've ever tried to use a tripod somewhere, I've run into the same problem. But yeah, I mean, you keep in mind that it's not just a free speech question, because there are other legal implications. So like Nancy said, if you're blocking access to something or causing some sort of interference in the regular, you know, flow of traffic or you know, some city, something, transport, whatever, you're going to run into laws that supersede your right to document.
I see Heather Cameron says, I have a Getty Images news photographer anecdote on this theme.
Yeah, let's unmute Heather, because
I'd love to hear it. Yeah,
she is very entertaining, and I'm sure it will be a good story.
I have the background in the legal stuff, but I don't have it. Stocksy doesn't have editorial, so I haven't had this come up specifically. So I'd love to hear from her.
I do remember this came up when we had a horrible hurricane situation, New Orleans devastated, just horrible. And our photographer, Mario Tama, he's one of our staff photographers, he was there shooting, and he shot very specific perspectives of the devastation all over, and especially in the Ninth Ward. And then a year later, he went back and he tried to stand in the exact same place and get the same perspective and try to show how things had either changed or had absolutely not changed and things were still devastated. And much to his surprise, suddenly the police rolled up and arrested him for trespassing. And he's like, but wait, I'm here trying to recreate this shot.
Right.
And he was arrested. I had his bail money. I mean, we handled it. But the homeowner, the person whose property it was, where there really wasn't a home anymore, it was so destroyed. It was logical that Mario maybe wouldn't have assumed anything about the trespassing factor. But there had been so many looky-loos coming into the Ninth Ward as sort of like weird tour groups and like that really bad macabre spectator creepiness.
Yeah.
And the neighborhood was over it, and they were sick and tired of people kind of coming in and not being respectful of that space. And once the homeowner realized that he was actually a journalist trying to shine a light on what was going on, the homeowner was fine and dropped the charges, and it was no longer an issue. But there is that strange tension between, you know, sort of trespassing versus First Amendment, and the access rights issue. You kind of always need to know where you're about, and do you have permission to be in space and time to get that shot, because that access right can absolutely limit the licensing potential or the ultimate end use of that content.
Definitely. And that's a good, I mean, that speaks to my sort of echo that I had throughout, which was to have calm conversations and respectful interactions. And, you know, you may be able to find out whether, you know, someone's okay or not.
Yeah. Thank you, Heather.
Thank you.
Thank you.
I could probably answer Mark's question, even though Amanda's not here, because it's just a general.
Do you want me to read the question out?
Yeah.
Okay, so Mark says, I wanted to ask Amanda about the drone property release, if someone can help answer. So if the drone captured a wide shot of private property with substantial percentage of public cityscape, do we still need a property release of the private property?
So this is a question that comes up a lot, like when do you need property releases? And probably everyone maybe remember that Barbara Streisand's property in California was, I think, shot probably by a drone or aerial. And, you know, she kind of had a fit that it invaded her privacy, but it turned out there's really no privacy rights if you're getting a high aerial view of private property and a cityscape, because personality rights such as right of privacy and right of publicity only apply to people. They don't apply to real property. So you'd have to be violating some other California or local statute if you got so maybe too close and flew too low would be possible. But if you're getting an overall cityscape, for example, there's no rights in a skyline. I mean, I know certain buildings have tried to claim trademark rights in their buildings, which is fairly difficult to do. But a lot of it is just the harassment you get when a homeowner recognizes their property in a shot versus whether there's really a legal action. I think California also once had a claim from San Francisco of the painted ladies, which are sort of a row of houses with all different colors. And some bank, I believe, had used a photo of them in some ad. And the court went through the type of claims that they tried to bring and said none of them apply. There's no personal rights in the buildings. There's no trademark right. There was no trespassing in that case. If there's logos and McDonald's signs on things, you could, in those cases, maybe have a trademark issue. But it's real property has a hard time fitting violations by taking pictures of them from a public place into any sort of real legal claim.
Yeah, and I think it's clear what you said, your analysis there, but I think to make it even more clear for Mark is that the analysis isn't really different when you're thinking about regular photography or drones.
Correct.
It should be the same. So I see that we have another question from Leslie, who's asking about the CASE Act. She says, what is the time frame for the CASE Act? And do you have a sense of whether or not it will be passed by the Senate? I'll give that one to you, Nancy.
Okay, I am turning over my crystal ball. The last I heard Wednesday is that there's talk about getting it to the Senate floor despite the hold that Senator Wyden has. Apparently Wyden has come up with his own proposal that is a way of totally gutting the act. It would have no statutory damages at all, so that's not acceptable. But I guess there are different ways bills can get to the floor in the Senate. And I believe it's by trying to attach it to another bill. So I can't say that it will. There's definitely, desire, and there's a lot of talk in the background. There's many senators that do want it. It almost universally passed the House, and it passed the Senate Judiciary Committee. So it might be nice for the Senate to leave this year with something positive that's happened versus the rest of the year. So, it's like fingers crossed, don't hold your breath. If not, try again next year, I guess, see what happens. But it some days feels hopeless and some days feels like there's also a glimmer of hope for this, but there's still a lot of interest in it, and and it's something that's completely needed. So we'll see what happens.
A question from Doug Siegel. He's asking about the Copyright Office compendium to copyright holders, and is talking about being proactive, having some responsibility about having an easy way to ID images or easy way for clients to know from who/which entity. And he's asking, are there any more contemporary compendiums, under the current administration that's further talking about this issue? So I can briefly say that the current administration hasn't made this as an issue in the same way that the previous administration has, but it doesn't mean that it's not an issue. And I think the Copyright Office has been talking about it. It's mostly framed in the context of modernization of the Copyright Office, as well as reform to the DMCA, which Nancy and I talked about yesterday in a separate panel. I do think it also fits very nicely with some of the other efforts that our industry is doing, such as the Google licensable badge, having metadata that shows ownership, as well as the content authenticity initiative that Andy Parsons from Adobe was talking about earlier. Showing provenance definitely goes to being able to prove ownership and having more transparency in the licensing industry, where someone who needs to license something knows where to get it from. I think that the sort of meet the obligations that the previous administration was talking about. I'll open that up to anyone else on the panel if you want to talk about it.
I might add that the compendium is really the Copyright Office publication that talks about the practice of actual registration. It's really the inside guide that gives information about how to properly register works. And there's a separate initiative dealing with copyright modernization and the Copyright Office ability to search and store and update all its technology. So the compendium is now a semi-living, breathing document. It's no longer printed, it's electronic. It has had several updates. Often the Copyright Office will open it up to questions. And the Copyright Office has been actually updating some of its registrations, in particular group registrations, in light of social media and the internet. As of yesterday, you can now register what's called sort of short articles, ideally like blogs in a group, because at one time you never could do it. It had to be an actual serial where you were a formal publisher and did something like once a week or once a month. But there is now, if anyone of your clients or anyone in there does produce blogs, there is now a new registration that was in beta that started yesterday. So you can do a group of them together, and they have to be under a certain amount of words. So that's just an example of some of the things they are doing. If you are registering photographs, they have now a group registration of published photos and a group registration of unpublished. So at one time it was unlimited, the number of unpublished photos you could do, and now it's the same limitation, I think 750 as the group of published. So the compendium is where you would go if you want to look at the right way to register something and what is even protected by copyright. There are things about social dance on there, exercise moves, things like that. They give some guidance.
Thanks, Nancy. It's very helpful. So I don't see any more questions.
I have a question, Paul.
Okay.
It's actually for you, Sejal and Margaret, following up on the tattoo cases that Nancy was discussing, to see if the agencies you represent how they're handling photographs that include tattoos, let's say, that are easily recognizable, and obviously for non-editorial use.
Sure. The laws surrounding tattoos have been sort of ever changing. And so we have a general policy of requiring releases for tattoos generally. And then, internally we have some guidelines for our reviewers to sort of draw a line where, something might be more visible than it needs to be, or maybe it's okay and we can accept it. So there's definitely a lot of discretion that's used in terms of, figuring out whether something is risky or not. But generally, we do require property release for visible tattoos in content, especially static content, because, the more recent cases that have come out are all involving the use of tattoo art in video games and social media, gaming, and things like that. But the type of content that we're licensing, with the exception of our audiovisual and movie clips, they tend to be more static. So that's sort of where we're looking at when we're drawing our lines for risk. I'm not sure if that answers your question explicitly.
Oh yeah, definitely, yeah.
And with editorial content, though, you have to depict the person the way, authentically the way they are. You really can't change that. So
right, and that's a great point.
Yeah, that's why I was really focusing on commercial.
Great. Thanks, Sejal. There is another question that has come in from Allison. She is asking, are there any best practices when managing UGC or user-generated content? There are vendors who offer services to take UGC and get it approved for advertising using only a hashtag for approval. This contradicts our best practices of using UGC outside the handle it was posted on. The person who created the piece of content, the individual who uploaded it, the people featured in the content, permission from any third-party rights owners if needed. All content complies with privacy laws. I think that is a really good question. I think it sort of relates to the social media question. Sejal, do you want to take that one?
Sure. Let me make sure I understand this question correctly, because I might be interpreting it differently from embedding. It sounds like the question is about best practices for when services offer to take user-generated content, I'm assuming on social media platforms, and then trying to get approval from whoever posted that image for commercial usage. Is that correct? I can answer this as I understand it, and hopefully it's the right thing, but please feel free to follow up in chat, Allison. So I think what you're saying is if somebody has an image on social media and the practice is, respond back with this hashtag to give your consent to use it, is that a good practice? And of course, it's highly dependent on what the image is and what you intend to do with it. The thing with social media is, yes, people who are posting on it are making representations about their ownership of the copyright or their ability to post it, but it's a little bit of the Wild West in terms of actually knowing who is posting what. So, hashtags are a quick way to do it, and I know a lot of social media teams and marketing teams like to use that. I think, of course, it's preferable to have a little bit more information, especially depending on what type of end usage there is. If it's within the platform, it might be a little bit more, not just convenient, but a little bit safer to do it that way. But if there's some anticipation of taking that content with the hashtag consent and posting it elsewhere, then it's probably, I think that would be a little bit more of a concern and would require better practices than just hashtag consent.
It would also be kind of interesting to see the agreements between these vendors and the people creating the UGC to see where they're putting responsibility in terms of the reps that you're talking about in your question, Allison, as far as the content itself and who owns it and who has permission to actually post it and provide it. That would be kind of interesting to see.
Yeah, and I do know a lot of brands will engage in that sort of hashtag consent when it's advertising their own brand. So maybe somebody has a piece of designer furniture from somewhere and they tag that, and then that designer on social media will reach out to them and say, hey, can we use this? Just put this hashtag and we'll repost it to our page or whatever. So there's also that consideration. I think a lot of brands are sort of looking at the risk assessment of actually what it is that they're reposting, and maybe they feel like it's defensible and doesn't require those additional agreements. But to the extent that you get out of that realm of maybe reposting or hashtagging something related to your own brand, I think it gets trickier, and I definitely think it's worth it to look at the underlying agreements for that content to protect yourself.
Yeah, I would reiterate what Sejal says. I mean, so many marketing departments want, anytime they see their content in someone's Instagram, they want to be able to use it, and the hashtag is easy. And all the digital media lawyers that just do corporate stuff in my office are always saying, "Oh, can't we just have them hashtag? It's okay." And there always is risk, because you don't know the person consenting is the one who took the picture or the one inside the picture. But there was also a very recent case where a designer, I think Eli Tahari, took someone's Instagram picture because their content was in the photo, and the photographer sued, and Eli Tahari tried to make the claim that there was either implied consent or fair use, and they lost. So I think there is some risk with sort of that easy hashtag, just say it's okay.
Absolutely. And the risk of the negative PR is also something to consider. You know, is it worth it for, you know, in one situation, maybe the subject of an image, or maybe like the rightful copyright owner, if somebody didn't actually upload their own content, coming out, because just as you're on that platform trying to market your goods or services, you're also opening yourself up to negative PR. So, you know, an interesting example that happened a few years ago involved, I think it was Dwayne Reed tweeting an image of Katherine Hagel shopping at Dwayne Reed. And, you know, that's something that I think a lot of marketing teams might be like, oh, it's showing somebody who's using our product or business, like we can just tweet this picture of her coming out of the store. And she sued for that usage. You know, she thought that it was, or at least her claim was that it was a violation of her right to publicity, and they got a ton of negative PR for that. And ultimately, whether it's fair use or not, or, you know, whether it's allowed, that won't really matter if you're getting a ton of negative publicity for that usage. Sometimes it exceeds maybe the benefit of just, you know, being able to use this content the easy way.
Thanks, Sejal. Hopefully, Allison, that has answered your question. So it looks like Tom has another question and his hand is raised. Let's go to you, Tom.
Hi. Yeah, so I had a question. You've mentioned a couple of times that there's different standards for professional journalists versus citizen journalists. And I'm wondering, because we're a small agency, we use a lot of freelancers, what kind of best practices should an agency put in place to make sure that our freelancers or our staff are considered to be professional journalists? Is it, you know, membership in an organization like the DMLA or the NPPA? You know, press passes, following standards? Is there any legal framework, or is it just sort of a, you know, doing it in good faith? What can we do to make sure that when we send someone out into the field, especially to document a protest or to document COVID, that they're going to be considered the professional that they are?
Yeah, I think certainly if there is an ability to have press passes for any particular event, that's going to be useful. And without being a press photographer myself, I suspect that there may be different expectations set, you know, depending on the event and what the pass covers. You know, I think it would be worthwhile to connect with some of the additional resources that I mentioned, particularly the Reporters Committee for Freedom of the Press and the Society of Professional Journalists, as they are, I suspect, very well versed in these topics and would have the most experience in providing you the framework or the details that would be that would help ensure that you have that professional journalist, that protection in place. But it is fairly specific. I would talk to a lawyer who works in that arena specifically, because they'll have the most understanding of the nuance there.
Paul and Nancy, can I ask you a Section 512 follow-up question?
Ooh,
sure.
On the spot.
It should
Yeah.
be a pretty quick one. In the past, in particular when I was in-house counsel, we took the position that unless you were registered with the Copyright Office as an online service provider, you were not entitled to the safe harbor provisions under the DMCA. And this happened a lot with, obviously not with the big ISPs like GoDaddy, AWS and things like that, but with smaller user-generated content types of sites that tried to claim protection under the safe harbor provisions. Is it your take that that's an absolute requirement to be registered, or is there wiggle room there?
Do you want to answer that, Nancy? Or I mean, I can tell you it's in the statute that is a prerequisite of getting safe harbor is that you need to register a DMCA agent.
Yeah, I agree. It's a clear. This isn't something fuzzy like, you know, red flag knowledge. I mean, it is one of the qualifications in order to have this kind of immunity. Is you have to have you know, filled out the registered agent form and have it on file with the Copyright Office. And also you better make sure that your email address works. I remember there's an older case, which is kind of laughable. It was like AOL had filed its form with the Copyright Office, but the link, whatever, their email didn't work. I mean, it was like a dead email. So it was kind of ironic.
Yeah. Yeah.
So
And I mean, I think that there are damages issues, right? So I think often what you will find is that if somebody gets called out as not having an agent, they will register very quickly. Right. And then the question is, okay, so now they have a registered agent. Are they liable for infringement that happened before then? I would think so, but probably not after. And and there really is no excuse to not having a registered agent. Especially, even in our industry, all of our companies should have a registered agent. It's free. It's very easy to do. I think it's an indication that a company that is claiming DMCA protection but doesn't have a registered agent is up to no good.
I think it might cost like $5.
Mm.
But basically free.
Basically free.
And easy.
Great. Does anybody else on the panel have any other questions or any other issues that they would like to bring up?
If we just want to talk about social media risks, there's I don't know if everyone remembers the case involving the wedding at one of the Trump properties, the Hearst, Otto v. Hearst, where someone, snapped a picture of Trump at the wedding, sent it to another friend that went to the wedding. That person, I guess, went and published it widely, and Hearst Media took just used it as and Hearst was sued for copyright infringement. Now, it got minimum damages, $750, but there is risk in relying on social media because you really don't necessarily know if the person who posted it is actually the one who took it. So, that's just it's just harder to do due diligence with social media.
Yeah, I think that makes sense. I would like to, since Dan, you've been popping questions, maybe put one back on you to sort of a reminder of the copyright enforcement guidelines that the DMLA has put out, and I think give you a platform again to sort of quickly remind people that that's out there and why it's important that we have this and respect these sorts of enforcement guidelines as an industry.
Yeah, really what we want to do is to ensure that when services are acting on behalf of copyright owners, that they're doing it the right way. And so that doing proper due diligence, making sure it's a valid claim, communicating with recipients, infringers in a clear, easy to understand way, making it clear that they're not lawyers. And really the basic idea is that it's hopefully helpful to the enforcement services, many of whom are members of DMLA, that they stay on the right path and we don't get these situations where, and these situations don't involve services who belong to DMLA, but where it's happened in the past of making egregious demands that really don't have any kind of basis in reality. And going back to the example of the case that Nancy cited with the photographer who is offering his content for free and then trying, only settling cases for $5,000-$10,000 or something like that. It harms all of us if we're kind of cast with a broad brushstroke of engaging in these kinds of practices. And so that's the idea, and that's the hope, is that really it's a valuable tool and resource for anyone and also for clients as well, and for all of our members who are engaged in copyright enforcement, to take a look at the guidelines in terms of what they should be doing. And also going back to the stock food case that Nancy mentioned, making sure that your contributor agreement gives you the rights that you need in order to enforce copyright. So that exclusive licensee, if copyright isn't assigned to you, then you have this exclusive licensee relationship where you do have standing to bring a claim for copyright infringement and to assert copyright in your works. So that's the idea. They're still not live on the website yet, but we will. That'll be my mission starting Monday, is to get those up and running, and we'll get the word out on that, exactly where they are on the website. But feel free to reach out to me directly, dpollock@dipshan.com, if you'd like a copy, or any of us, and happy to provide that to you.
And thank you so much, Dan, for doing it. You put a lot of effort into it. And just to remind everyone that these are guidelines. We're not saying that, everything has to be applied literally. There could always, be exceptions, but a lot of us looked at it and we got comments from a lot of those even that do enforcement as well, to try to present something that was reasonable for everyone.
Valerie asks, what about sharing a campaign in social media? This happens a lot for Tetra, i.e. Outside Magazine used one of our images for their cover. Can we show that cover on our Instagram account and tag our photographer? What about for an advertisement or commercial usage? Sejal, do you want to hit on that one?
Sure. So this is sort of going to get my lawyerly answer of this depends on a lot of different things. But, the way I would look at these questions is, first, think about if there's an underlying agreement between you and, whoever initially used the image. So if you have an agreement with Outside Magazine, like what does it say in there? And also take a look at, what is the art that's being used on the cover? Is it just your image, or are there other images involved? And then lastly, for reposting it to your own social media or your own marketing campaigns, you also have to think about the fact that there might be a trademark issue here as well. You're using potentially, the name of the magazine. Would they be okay with that? And so there's a lot of different layers. And even before going into an analysis of like, oh, is this a fair use? And is it okay because it's just, me showing what my work or my agency's work looks like or has been posted in a magazine, it's helpful to sort of parse out all of those details first. So I can't give an exact answer because I don't know the full details, but I think it is really helpful to sort of sort through those three things: the underlying agreement and relationship that you have with the magazine or whoever used your image, what the actual usage looks like, and if there might be any trademark issue with posting that usage into your own social media, because you don't want to create an unintended false association with that magazine without them giving that consent.
And I just want to toss in there that there are a lot of agreements. I find, especially with stocks, that have clauses built in that say you can't mention that they work with you. It's my marketing team hates my guts because those exist in so many places. Yeah.
And outside of that, a lot of the times when these things pop up on social media, you want to share it pretty quickly. These things come with like this timeliness consideration, and it's ideal to get something in writing, and we all want something that's buttoned up and in paper and in signature, but, acknowledging that these things can move pretty quickly. It is okay to email whoever used that image and, get their consent in writing and things like that. There are other ways to do it. And I would advocate for that above just making the unilateral decision, because ultimately this is your reputation within the industry and, with magazines, and you also want to think about preserving that and maintaining that as well.
Great, thank you, Sejal and Margaret. I think that was a really good answer. So we're right up on time here, so I think we're gonna end it. Thank you very much to all the panelists. I think that was really good, and also for the questions that have come in.
Thank you, Paul, for being such a great moderator.
Thank you, and thank you CDAS for sponsoring.